The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. This afternoon, we have 4 cases that will be submitted to the court. 2 of them are submitted without oral argument. The case of Iowa Supreme Court Attorney Disciplinary Board versus Brian O'Brien is hereby submitted without oral argument. And the case of Jesse Embers versus Western Agricultural Insurance Company is hereby submitted without oral argument. The first case today is the Rausch Family Trust versus City of Marion. I believe Dean Spina is representing the Rausch Trust. You may both come get situated, and we'll wait till you're ready till you start. Mr. Spina, you may approach. Do we have Mr. Goodwin today? Is that correct? Yes. Thank you. You may begin when you're ready.
This is a condemnation of a part of a 9.57 acre parcel owned by the Rausches since in the 1970s. The property is irregular shaped, and believing that the condemnation of a right-of-way, fee title, and construction easements dramatically impacted the future development of this property. It's vacant. Rausches believe that the value was something in the neighborhood of the difference in value between before and after taking was close to $800,000. The jury awarded $85,000. We were unable to have the jury hear the basis for the opinion of the lay witness, Mr. Rausch. He is a beneficiary of the trust, and he was able to testify as to a value. He gave a value of $12 a square foot, but he was not able to testify as to the basis of why he came up with that $12 a square foot. We had sales transactions that supported that number, but we were unable to introduce any of that due to the motion in limine and the trial court's ruling excluding that evidence. If you're looking at the parcel, it's page 47 of the appendix has the parcel, and it shows the area being taken, the guts of the parcel being taken, or the guts of the parent tract is what was taken. The parcel is located on Highway 100, a 4-lane divided highway in Marion. It is controlled at that point by a traffic signal. It is zoned Commercial 3, which is general commercial in the city of Marion, allowing just about every use that's a commercial use. We were unable to introduce evidence of comparable sales, despite a ruling in Redfield versus Department of
In the Redfield case, didn't an expert put on testimony about the other properties? It wasn't the actual owner, as in this case, was it?
As to opinion in that case, as I recall reading it.
Was there an expert that testified in that case also? In this case, there was no separate expert. Do I have that right?
Plaintiffs.
Do the parties agree that the son or Mr. Rausch could stand in the shoes of an owner, even though it was more of a contingent or he's a beneficiary?
Yeah.
And isn't it kind of Hornbook law that owners are allowed to testify as to value?
Yes.
And a real estate, isn't it the standard method of supporting your valuation to look at comparable sales?
Your Honor.
The trial court barred the testimony on grounds that he did not have personal knowledge of these other transactions. He wasn't a party to them.
The reason I think the for the trial court decision.
True, most of the time, somebody's looking at other comparable sales. They're not, they're looking at land records.
Number of Iowa cases where owners or representatives of owners who were not experts testified. And I believe most of those cases that I saw, there's myriads of cases, did involve witnesses who did not own the real estate that was sold, but they were aware of because they lived in the market. That is true for our Mr. Rausch. He did not know, he did not own the properties that were sold. He was able to identify the properties, enough detail about the properties to in his opinion, treat them as comparable to this property. The leading piece of evidence that we had was a sale some 10 months earlier in Cedar Rapids, near the second regional mall, shopping mall in that city, that sold for $9.25 a square foot in on a Highway 149, which is a 4-lane divided, also at a traffic-controlled signal intersection. The evidence was excluded, and so when Mr. Rausch testified as a $12 a square foot, and I realize $9.25 is less, but there were reasons for $9.25 being less.
Who determines whether or not the other property that the owner wants to testify about is sufficiently similar? Does the district court decide that? Does the expert? Does the person testifying?
Language in the Redfield decision and others does state that it's for the trial court to make that determination as to admissibility of the comparable sales. And then details about the comparable sales go to the weight of the evidence to be determined by the jury.
Did the district court make that determination here, or did he leave that to the city's expert? Was that part of the basis for excluding the evidence, was that it wasn't sufficiently similar?
Stated basis in the ruling. It's a short ruling. It just said that we were not allowed to introduce any evidence of the comparable sales relied upon by the plaintiff's witness.
If I understand the rule correctly, an owner of property can testify about the value of their own property, right? And the primary issue here is whether he can then bring in other sales of other properties. What would give an owner of property expertise about a comparable sale of different properties?
Well, knowing the details of the property that's being condemned, the zoning classification, which allows certain uses or does not allow other uses, the location, the size, all those details he knows because he owns the property, he or she owns the property, and they can determine that this property over here, we think, in their considered weight of analysis, is comparable. It's maybe slightly smaller, or it's larger, but it's within parameters that it's not 80 acres versus 5, it's 3 acres versus.
Couldn't a non-owner get that info also and compare different properties?
Belief that it shouldn't be restricted to a non-owner under, because what we're dealing with is personal observations it's of the sale property. You can learn about a sale by seeing a sign up and then it's suddenly something's being built there. You can investigate on the recorder's websites to find out what happened, what was the sale price based upon the deed, which is what we had here. You can look at a plat, recorded plat, to determine the area. With those two pieces of information, you can determine, as our primary sale was $9.25 a square foot.
Exactly did your client obtain knowledge about the other sales from the deeds?
Invested in this property originally. She invested other property, and subsequent to that, sold other property in 80 acres for residential development in the city of Cedar Rapids. Her husband had died in 2002. Her son, James Rausch, primarily helped her with the decisions as to the reinvestment of that money.
The comparable sale documents that he looked at were what? What did he look at?
The deed for the property from Menards, Inc. to the Unity Point for a medical clinic.
Relate the value for Menards based on looking at the deed.
Itself sets forth the transfer tax, and the transfer tax is $1.60 per thousand of value. And so by dividing the transfer tax amount by $1.60, one can get within $500 of the consideration paid.
Tax, as I understand it, doesn't necessarily reflect the value because it includes other things like personal property that may be included as part of the sale that wouldn't necessarily be disclosed under 428(1) sub 1 sub C. And it also has set-offs for encumbrances on the property that the buyer may assume. So the tax itself wouldn't necessarily reflect the value of the property, right?
The property that I'm referring to was vacant land, so there was no personal property to deal with. There was no evidence in the recorded documents that there was any assumption of a mortgage that might have been on the property in the name of Menards.
General proposition, I'm not sure that it holds that looking at the transfer tax in any way reflects the actual market value of the property.
You don't have those other considerations. If there's no personal property, and you have to disclose the personal property on the declaration of value. If it's not disclosed, then it basically, you have to assume that all of the value went to the real estate, not any personal property.
Requirement that an assumed encumbrance be disclosed, right? So if somebody purchased a property for $1 million and assumed an encumbrance or a mortgage of $500,000, they could record that as $1 million sale, right?
That's what the seller would have received, $1 million in consideration.
Off by the $500,000 encumbrance, so you'd be paying tax on $500,000, right?
No, you'd be paying tax on the full $1 million in terms of the transfer tax.
Property may be $1.5 million.
Higher than yes.
I guess if the owner doesn't have personal knowledge of the details of the transaction, it seems to me that just saying, looking at the tax certificate gives you knowledge of the value is just incorrect.
That's, I guess, a potential, yes. I hadn't thought of that.
I asked him a question related to Justice McDonald, what he's explaining. In a typical case, how does the appraiser find out what the comparable sold? How do you do that? A real expert.
An expert will, or an appraiser will, as they work in the field, they keep track of sales. Assessors typically have now easily accessed databases that you can put in parameters for a search and find sales of buildings, residences, vacant land. They tend to be broken out in those categories. And from that information, then look at the property and what they can glean from, say, multiple listing service. And there's other services that will identify property and the sale prices and the considerations.
In terms of the efforts to discover the actual sale prices of these alleged comparables, is there anything different between what your client did and what a professional appraiser would have done?
The professional appraiser will have access to the multiple listing service because they pay a fee to get access. That is my client and our client did not.
I mean, in a sense, when an appraiser comes in and testifies, they're really offering two expert opinions. One is what the overall value of the property is, and then the other, to the extent they're talking about comparables, which they usually are, they're offering an opinion that these other properties are, in fact, comparables. So my question is, just because we've ruled that we're going to allow the owner to come in and give the former expert opinion, that is, testify to the value of their own land, what is it that logically follows that they should be also given the privilege of giving an expert opinion that X, Y, and Z are comparables?
It is my approach to this case that the decision that the other properties, it's not so much an opinion as to whether they are comparable, but it is the facts about which those sales evidence. It's the size, it's the whether it's flat, whether it's hilly, whether it's forested, all those facts which they can glean by looking at the property are facts. And the decision as to, I think that one meets the criteria, it's a fact, not an opinion in that regard.
And follow up to that, one of the properties here, and please correct me if I'm wrong, you know the record better than I do. I thought it was just a printout from the county assessor's site. Is that right?
Exhibit followed the exhibit of the deed from Menards to Unity Point from Medical Clinic, and it's that properties as it was shown in 2017 with improvements on there. The medical clinic hadn't been built.
It's related to the same comparable, this Menards property. Okay, thank you.
Thank you. You'll get a chance to come back to the podium in a few minutes.
May it please the court, Mr. Spina. The trust actually wanted James Rausch, the son of Phyllis Rausch, the trustee of the family trust, to give two opinions. One, the fair market value of the trust property. He was allowed to do that. There was no question about that. And his testimony was that, in his opinion, the property was worth $12 a square foot. That equals $522,270 an acre. He gave an opinion that the damages were $800,000 for a taking of 0.63 acres. That's over $1,269,000 per acre. He was allowed to testify to that. He was not allowed to testify to his opinion of whether or not some sales that he saw online on the assessor's website, of which he had no personal knowledge, were comparable to the trust property.
Agreed that it was appropriate to allow him to testify about his opinion about the value of the property?
Yes, we considered that. Phyllis Rausch had a physical, mental issue that wasn't able to testify.
Whether or not he was the owner. You agreed that?
Determined that he has personal knowledge of the property, is a beneficiary of the trust.
Allowed to testify about the value of their property, and we're talking about commercial property, but he's not allowed to testify about the basis for why he came up with $12 an hour. What good does that do how does he support that?
Comparable sales of which he has no knowledge. And some of the background in this case is the trust had two appraisers available. They didn't identify them, undoubtedly because they wouldn't come up with a high enough figure. If a appraisers had testified. They are expert witnesses. They are qualified to identify comparable sales from their knowledge and training and skill. So there are two opinions that exist.
We're not talking about those. I'm just talking about the basis for if an owner is allowed to testify about their opinion and it's commercial property, it makes it pretty hard for him to testify about, why can he not at least testify how he came up with that amount? That seems to be kind of what the issue was.
Whether the sales of the online sales should be entered into evidence as evidence themselves. He was able to testify that he went online and looked, and in his opinion, it was $12 a square foot.
Say, and I base that $12 per square foot on my review of these other sales. Not even.
That he went online and looked at the assessor's website. The issue was not
Properties. So he.
Identifying properties because he has no personal knowledge.
I just want to make sure I understood you. He could not testify as to specific properties he looked at, just that he generally looked at other properties.
I think he did testify to certain properties that he looked at in Cedar Rapids.
Valuation of the specific properties because he didn't have personal knowledge.
But he does not have personal knowledge of those sales. There's all sorts of conditions that are involved.
For a lay witness owner to get personal knowledge to satisfy your city's view.
I had one witness that was a developer that was personally involved in one of these sales. However, they didn't call him. He testified that the project enhanced the value of the property, and he wasn't. They didn't want to call him. But if someone would actually have actual notice of what happens in a particular sale, I think that would probably give them standing to have.
Issues, and it seems like maybe you're, correct me, maybe you're bouncing back and forth between them a little, and maybe the trial court did in its ruling. One issue is how well does Mr. Rausch have knowledge of the actual sale prices that's reliable information or not? And we can argue about that, whether the assessor site is good enough or you need to subscribe to this MLS thing or whatever. And the other issue is, even if you know what the sale price is you allowed to say they're comparable? Because Redfield says the court still gets to screen the comparables and decide whether they really are comparable. The owner's privilege to walk in and say, I think my property is worth a lot, is not necessarily what, doesn't necessarily mean that they have a privilege to say that different properties are comparable. That might require a greater degree of knowledge.
Redfield case, it's very interesting. The court says all witnesses on value showed outstanding training and experience. And then it goes on, and they identify 9 different sales. And it says they were all, the sales, however, tracts which the experts recognized as being recently bought for the same purpose. And the court there were 9 sales that the experts identified, and the court allowed only 7 of the 9 to be admitted.
Let's say that this case isn't Redfield, but going along with the plaintiff's argument here, having knowledge of your own property gives you a better basis to compare it to other properties. What's your response to that?
And the trial court did rule that Rule of Evidence 5.701A requires the lay witness to have personal knowledge. they have personal knowledge of their own property. And in this situation, Mr. Rausch grew up on this property, and then they moved off to another place, but he was still familiar with it, and they rented it out. But he did not have personal knowledge of the comparable sales. He simply went online and found sales on the assessor's website and picked out whatever sales at the price he wanted.
That just be subject of cross-examination about the depth of his opinion versus an admissibility issue.
Well, I did ask him if it's $12 a square foot, you know, that equals 522,000 an acre. And he said, no. I did ask him a number of questions.
Shouldn't he be allowed to say, I looked at this particular property and the sale amount was X, and I looked at property B?
That, what he was prevented was from putting into evidence those online records.
The issue here is just the admissibility of the physical exhibits, the documents. So what role, if they had been certified or acknowledged under 622-36, then those could have come in, right? What role does section 622-36 play in this case?
You're talking about the evidence? Yes. Well, the that we have here is, well, there's no question if they are.
Section 622-36 says every instrument in writing affecting real estate which is acknowledged or approved and certified as required may be read in evidence without further proof. And then there's case law indicating, in reliance on that statute, in valuation proceedings, that these documents can just be admitted into evidence on their own as evidence of valuation, correct?
But in this situation, they were to be presented as comparable sales, and there's no evidence that they are comparable sales. And actually, our witness testified that he looked at these sales that Mr. Rausch looked at and said they were not comparable.
236, that doesn't relate to that relates to like a deed or a mortgage. It doesn't mean something you pull off the assessor's website. A tax statement is an instrument in writing, does it?
The issue we have here is that Mr. Spina asked even the city's witness about these different sales, and he said they were not comparable. The comparable sales that Mr. Passmore for the city found was directly across the street, the highway, and is sold for $121,000 an acre. And I'm confident that if they had had an appraiser available to them and called them, they would have found that same sale. So what we really have is the issue of, can an owner go online and find assessor's website sales, real high prices, and say, I think it's comparable. That is the heart, I think, of what we're talking about.
Trial court would still have a role, a gatekeeping role, to screen out sales that were just too far afield or too different to be comparable. But what would be the practical implications if we were to hold in agreement with the plaintiff's position that a lay person owner should be allowed to testify to what are actually, in fact, comparable sales? Is the sky going to fall, or what's going to happen?
There was an offer of proof in front of the trial judge. And again, rule evidence 5.701A says they have to have personal knowledge of.
Personal knowledge by studying the land records?
testimony in this case that was true. I think that would be difficult because all of a sudden that takes the expertise of an appraiser to have that training and experience to accomplish that when just an owner doesn't really have that background or training.
Why I might feel qualified to opine on the value of my own apartment that my wife and I own. It's not because I'm an expert on comparable sales or anything like that. It's because I was involved in negotiations to buy it. People have offered to come, offered to and in addition to receiving kind of informal expressions of interest, we've invested money in it. We have various degrees of non-public information that might give us the expertise to go out and testify as its value. What's troubling here is it seems like Mr. Rausch worked backwards. In other words, he had an opinion of what his own property was worth, and then when he came into court, he wanted to testify as to some things that were comparable without necessarily having expertise in that particular subject area.
Exactly correct. And again, they had appraisers available to them that they did not identify and did not call, obviously, because they wouldn't. The one appraiser testified.
In that situation, including me before, and I wouldn't want that held against me on a legal question, but I understand the practical implications.
But if we take Justice Mansfield's example, if he is able to opine about the value of his own apartment that he owns, part of that is going to be based on if he knows that the apartment down the hall sold and he knows how much it sold for. He might not have been involved in that personal sale, but he could go onto the assessor's website and find out how much that other apartment sold for. And it seems like cases recognize that owners are in a little bit special or a different category. They seem to be somewhere between a lay witness and an expert witness, and that's kind of where I'm interested in, is where they fall in that situation.
With our property, we have an opinion of what it's worth. But if we say there's 3 different properties and we have no personal knowledge of them, and then it's misleading to a jury and possibly confusing for us to say that we have no knowledge of those sales, but they're comparable to our property.
To ask you one more question, Chief, with your permission. Yeah, as long as I know I'm being marked down for and I'll pay the penalty later. But in any event, I mean, you keep saying no personal knowledge, but it isn't really no personal knowledge. I mean, nobody really has personal knowledge of other sales, including an appraiser, unless they were there at the closing. I mean, what you're talking about is they're not sufficiently expert to opine on whether a sale is comparable or not. That's a different issue, isn't it?
Well, for the landowner in this situation, to be able to testify whether an online sale that they found is comparable, in this case, there is no knowledge. You just don't have knowledge going online without further exploration of the facts.
This issue be resolved with a limiting instruction so that the witness can give an opinion based on comparable sales or what that witness believes is comparable sales. And then the jury can be instructed that goes to the weight of the opinion testimony and is not as substantive evidence.
I still think there's a chance of misleading or confusing the jury of just picking out real high-priced sales and saying, I think it's comparable, and then the court having to say, well, let's take a look at it.
This case, In Re Primary Road, issued by our court, goes into a pretty long discussion of this issue, and it concludes by saying this: Evidence of comparable sales may be used to test the qualification of an opinion witness, which this owner is, and also as substantive evidence. The difference between opinion testimony and substantive evidence is a proper subject for a jury instruction. And then it discusses that the judge can instruct the jury, this is this witness's opinion. These comparable sales go to the weight of the opinion testimony, and they should not be used piece by piece as substantive evidence of valuation. Doesn't that solve the problem?
Also, in Redfield, it says that the court has the discretion as to determine what is comparable or not. And I think in this case, it was determined that this witness really just wasn't competent or knowledgeable enough to put before the jury these sales that he just grabbed online with.
Shoot, giving us some great examples of how much his calculation would result in a lot of money per acre. Couldn't you do that as a lawyer too during your closing argument? Have an instruction that says this is not substantive evidence, and then someone like you comes out and says, if you take those numbers, have you done the math? Wouldn't that be effective with a jury?
I argue that to the jury because they had in front of Mr. Rausch said damage is $800,000, and that's $1.2 million an acre, and so yes, you can do that, but why do we want to maybe confuse the issue and make it more difficult when the rule of evidence says you have to have personal knowledge before you can testify and put into evidence what they claim to be a comparable sale that was just taken off the website.
Did you want to ask something?
Thank you.
Thank you. Mr. Spina.
Thank you, Your Honor.
The view. As I'm hearing this argument, it seems to me what we have is largely a district court management issue. You have the prospect of an instruction. You've got Rule 403 evidence. So the judge can act as a gatekeeper in the event that the comparables are out of sight. The judge can issue an appropriate instruction. Well, I'm not sure this is subject to some kind of categorical rule, and I'm wondering whether it isn't just best decided by the trial judge with the toolbox that the trial judge has. And isn't that what happened in this case?
What happened? The trial court order, it's very short. Just James Rausch's testimony does not even qualify as a proper lay opinion because it is not based on his personal experience or familiarity with the transactions he wishes to call comparable, and his information about the market value is based on hearsay about how others valued the property at different times. That does not allow us to say anything to the jury as to how this owner, who is involved with investing money in real estate with his mother's, she owned other properties. She did well for a diminutive little woman. She did very well. And he was unable to testify to anything because of the ruling. I'd like to clarify one thing. I'm sorry.
I don't want to cut off your clarification, but I will temporarily. I mean, as I listen to Mr. Goodwin, he keeps saying no personal knowledge. I look at Judge Grady's order, and he says no personal knowledge. I'll talk about it more at 8:30 in the morning. I guess he didn't, but what I'm really hearing them saying is that your client wasn't really qualified to testify that something was comparable or not necessarily that he didn't know what the sale prices were. And why isn't that a proper exercise of discretion within the realm of what Justice Appel is referring to?
Well, the ruling came out prior to our presentation of our offer of proof. There was a deposition of Mr. Rausch and his testimony before the jury trial started. I think Mr. Goodwin actually confuses what was in the deposition and that offer of proof for testimony that he was able to give in the court before the jury. Because we don't have that, I don't have that sense that we got that opportunity. Yes, it's a matter of trial management, but it's also recognition that virtually everything we know, we learn from somebody else. Whether it's the sale price of somebody's home or this vacant land that was developed, we know from other sources what happened. And here we are not able to tell the jury, this is how I got here. Yes, it's a significant dollar amount. $12 a square foot is not unusual for commercial land.
Let's say Mr. Rausch's nephew, who had never lived on this property, were to testify, and he were to say, I went to the assessor website and I printed off 5 properties, including my uncle's property and 4 others. And I think that the value is X based upon my review of these documents. Would he be permitted to do that, or should he be?
Knowledge of the property to which he's then comparing other properties, I would say, you know, I perhaps not is best I can say. I think it's there's so many factual issues in terms of our properties comparable. How did you learn about that property? Did you go on the site to know that it's flat or it's hilly, it's rough terrain, it's treed, it's forested? One of the properties that Mr. Goodwin's expert relied upon across the highway was bought for residential development for senior housing. It wasn't bought for general commercial C3 multiple uses. That's a big difference in terms of valuation of property. Just saying that a property is for sale, no, you'd have to know more than that, or that it was sold for something. You have to know what it was sold for. What was the purpose of, how was it, what costs were involved to ready it for development. That should factor into the valuation of that property across the street. Was forested. It had to be clear cut, basically, to enable this. The rule as to competency of value witnesses is to be liberally construed in favor of admissibility. The extent of a witness's qualifications goes to the weight of the evidence. We did not have that opportunity for the jury to decide what the weight of the evidence was. Thank you. Thank you.
The case of Rausch Family Trust versus City of Marion is hereby submitted. And we'll have a little transition here before our next case of Carreras versus Iowa Department of Transportation.